Hey, everybody, it's Kathy. I hope that you are all doing very well wherever you are, whether you're joining us here in the United States, if it's the afternoon or the evening. Hopefully, you're having a great day. I am doing this. I'd actually had planned to do a podcast on the new case that we're covering, State of California versus Nick Reiner. But one of our very long term supporters, listeners, and friends, I consider them from across the world, really. It's morning where they are right now, have been following me for many years, even before I converted my podcast to true crime, and were wanting me to cover a little bit of Kohberger tonight because it just basically said we're stumped what's going on with the Kohberger case. Could you please speak about it a little bit and then, feel free to go into the other case? And I said, sure, why not? So I just wanted to begin by going over what I considered to be our first case that I'd like to address tonight, which I considered the trial of the year of 2025 that never happened. That would be State of Idaho versus Brian C. Kohberger. And then we're going to get into what I think is going to be the trial of the year for 2026, which is this new case, State of California versus Reiner. So I wish to everyone out there that wants an update on Kohberger that I had something for you. I just checked the docket in Ada County where it is just about 5 p.m. So court is getting ready to close. I've been going on that docket probably about 3 times a day just to see if there's anything new from Judge Stephen J. Hippler. And I am sorry to report to everybody that's following Idaho versus Kohberger, there is absolutely nothing as of today. And it's the evening of the 17th of December here in the US. I know some of our listeners are already into Thursday morning, the 18th, but it's the evening of the 17th. There's nothing on the docket. There hasn't been anything published on the docket in Ada County. Let me just check one more time because it's right now 5 p.m. and maybe Hippler threw us a curveball and filed something real late. Nope. It is the last things they've been on the docket for a while. They were the November 13th, 2025. They were the orders on restitution following that hearing that Judge Hippler had on November 5th. The court orders from that hearing that was on the plaintiff, the state of Idaho's motion for either restitution or additional restitution, whichever side that you feel was correct on that matter. There were 3 orders entered November 13th. That's over a month ago now. And now that the court's closed, the next opportunity for Hippler to drop anything on the docket is going to be the 18th. There's also been nothing on the case summary page. The last time the case summary page was updated, and the way that you can tell that is to look at the bottom right-hand side. Whenever it says printed, that historically has been the last time that the clerk of court has updated case summary. The case summary page has not been updated since before Thanksgiving. The last time that it was updated was November 26th, and there has been a public record that was filed by the state of Idaho, dated the 25th of November, that still has not been released to the public. And I don't understand this. Judge Hippler did this a few times when the case was proceeding, when it was a live case, getting ready, a pre-trial going into trial, where you'd see something come up on case summary once in a while. And the way that you can tell a public record is when there's a little PDF icon next to it, as opposed to a lock and key icon. The lock and key icon are the documents under seal. This was a November 25th request, state's request for decision without hearing. A decision without hearing on what? We don't know because this request has been not released to the public since the date that it was filed, which was November 25th. And then on top of that, we still have now the third court order. You know what Hitler was doing when he announced that he would be publishing these periodic orders asking the sides, both of whom are responsible for this mountain of documents that were filed under seal. He's going to them. He's asking both sides, get back to me. Typically, it would be within 2 weeks. That's what the first three orders said. Get back to me within 3 weeks. Here are the documents that we're considering for unsealing. Give me your objections, non-objections. Well, the first court order that went out, which was for the months of July and June. He's going backwards from the end of the case backwards. That order he rendered a decision on within 30 days, and some of the documents that he released from June and July were released within 30 days. The second order, it was the next 2 months going backwards, April and May. He issued a ruling within 36 days. This third court order for January, February, and March, it's been 62 days. So it's more than twice as long already. Tomorrow is going to be day 63 that he could release something. Nothing, no decision as of yet after 63 days. And I don't understand. I looked on the Ada County website, where he put that. If you've seen it, there's a notification there saying case is closed. Judge is going to be going through this process. Be patient. And if you want information that's from any of the law enforcement agencies, Moscow Police Department, Idaho State Police, for example, Commonwealth of Pennsylvania, where a very important bit of information, which was the interview that they had with Mr. Kohberger in the Pennsylvania State Barracks shortly after he was arrested. That's in Commonwealth of Pennsylvania. I think that would be an incredibly important video, audio. To just imagine seeing him come in. He's being interviewed by Detective Brett Payne, walking into the Pennsylvania State Barracks. His house was just broken into, basically, when they effectuated that arrest with the Bearcat and the lights overhead. And here comes the feds and the Pennsylvania State Police and everybody else. And he's pulled out of his house. He's seeing his parents being detained. And who knows what they went through. They're people in their 60s to go through something like this. And he's pulled out of the house, but he's not taken to the Monroe County Jail. He's taken to the Pennsylvania State Police Barracks. That was the arresting agency. So he's pulled in and he sees a detective from the Idaho State Police, but the lead person interviewing him, because this jurisdiction is Moscow, was Detective Brett Payne. And the first words out of Kohberger's mouth, according to Brett Payne in his report, was, "Hey, Detective Payne, you look familiar." Now, I want to see that. I want to see him saying those words. And then a little bit later on in this interview, he said words to the effect that he had been doing work for law enforcement as part of his PhD studies at Washington State University. Well, I want to see their faces when he says that. And I would also like to see him saying that, because if one thing is for certain, these videos that have come out, body cam, the interviews down at the police station, Moscow Police Department, or some of them have even taken place in squad cars, interviews of, for example, Jack S. It doesn't seem to follow what the reports say. There's information there that is not captured in the reports. I want to see the actual videos. I want to see the audios. So I don't know what's going on with Hitler. As I've said, he's never taken this long. As a matter of fact, this is taking twice as long as any of the other court orders. Right now, the only thing that has been released, and mind you, this case has been closed for almost 6 months now. It was effectively closed the day he pled guilty, which was July 2nd, 2025. That was the date that the trial was canceled. So, yes, he was sentenced on the 23rd, and that was officially the day that it was closed. But I consider July 2nd the date that this case truly was closed, because it meant bye-bye public trial. We were waiting for so long to finally get to trial, because that's when, after not having a preliminary hearing like there was supposed to have been back in Latah County days, because the prosecution went to the grand jury, and once that indictment was returned, goodbye preliminary hearing. We were looking forward to this trial, all of this stuff that had been under seal. Well, that's not going to happen. So now I can't think of a legitimate reason why the case wasn't unsealed the day the case was closed back in July, because there was no longer a trial that you'd have to worry about, that the jury could be impacted negatively if the documents and the information got out. And I certainly do not understand why, after almost 6 months, this case is still largely under seal. Just think about it. This case ran for almost 2.5 years, and the only thing that's been unsealed as of today, going into December 18th, we're heading toward the end of the year, are a few documents from April, May, June, and July. That is it. Nothing earlier than April of 2025 has been unsealed as of yet, and he has still not issued that fourth order that would then get into 2024, would bring us to the end of 2024. And I'm sorry, having relooked at the affidavit of probable cause 3 years later, page by page, I hope that you are following that. We're doing what we did when we started the podcast, was to go over the PCA literally page by page, line by line, with now the benefit of some information unsealed. And I want to see the warrants. And that's the warrants were all filed, and everything under seal attenuant to the warrants, including the affidavit of probable cause, which supported the warrant for Mr. Kohberger's arrest. I want to see all the documents under seal. And we're not even going to get to that until he finally gets to the 2024 documents in this forthcoming fourth court order. So I hope, and I put a little plug out here, what we did in December is we decided that we were going to go back 3 years later, because the third year mark of the PCA, and I can't express to you how important that document is. Without that document, you might have never even heard Mr. Kohberger's name. That document is what got the warrant issued. And so we're going over it page by page, and we've done a playlist for the first 9 pages. It's out there. You can just hit the playlist and listen to it and read the PCA along with me. And we're going to do a second part of the playlist to capture the last 9 episodes. It's 18 pages in total. We just dropped episode number 16 today, so we're basically getting to the end of that. But without further ado, because I tend to, when it comes to Kohberger, I can just go off and talk for a year. I want to say hello to some people. Amy, very early, very, very early today. Thank you for being here. And Christina, one of my long-term supporters, member of the channel. I'm so happy. I know that it's Thursday morning for you as well. So thank you for being here. Hi, Leah. Glad to see you here. I'm really looking forward. Cheryl, hey, stand by. We're going to be going over the case of, I believe, the case of the year for 2026 that I know that you're interested in. Stand by. Leslie and Billy, very happy to see you here. Bianca, another member of the channel, thank you. Number 8, good to see you here. And does anyone have any thoughts, any opinions on what the heck is going on with the lack of any movement? I mean, is Judge Hippler on strike? Has he quit? Has he decided to, he's not going to do any more? I mean, November 13th is the last time anything appeared on the court docket. That's over a month ago. And I don't understand this delay with the documents from January, February anymore. Do you know what important documents are in there? Those are all the in limine filings, all of the motions in limine that both sides filed with, motion application, request for a court order, in limine, pretrial. They were looking for rulings on everything pretrial, from AT&T timing advance records having to do with the 8458 phone. Also, the 911 call. Yes, it's true. You've heard the 911 call, but there's still stuff under seal regarding that 911 call. How about the text messages? Would you like to read the actual text messages and not just rely on what Ann Taylor says are in those text messages, what Ms. Jennings said were in those text messages, and even with Judge Stephen J. Hippler in the chart that he made when he rendered a ruling on in limine relative to the text messages in the 911 call, as he did in April, and he had to have those text messages in front of him under seal in order to come up with those rulings. Hey, I see a lot of people here, a lot of hands up. Hi, Chihuahua and Crime. Glad to see you here today. It is frustrating, Bianca. It is. Cheryl is saying that she would like to see the actual text messages. A lot of people, even on the podcast, have been saying, look, if there's one thing, I really want to see the text messages, because now there's all of these videos of suspect vehicle 1 and what they did. And if you go back to the PCA, you'll really understand it, I think, because I had forgotten a lot of stuff. And I'm telling you, when I started the podcast, I went over that PCA page by page. So what we're doing now is retracing everything. What they did is they used the AT&T timing records and they went to cell towers, and they made it sound like the cell tower information could pinpoint where the 8458 phone, and the assumption was where the 8458 phone went, so did the suspect vehicle 1, and so did Mr. Kohberger in suspect vehicle 1. That was the entire argument that was made in that affidavit of probable cause. So if we could see the text messages, now that there's been some FOIA requests that have gotten the video of what may be one entire car, or it might be more than one car, people are split. Some people say, yeah, that looks like one car to me, and it looks like a 2015 Elantra, Kathleen, and I see no front right license plate. A lot of people tell me that. And then other people are saying, no, that's wrong. It's a different car. In fact, Detective Payne admitted in the PCA that there was a portion of where SV1 was supposed to be traveling that there was no camera footage. So he had to then write in there, based on his experience and that he felt that the car traveled from A to B and then finally turned up. I think it was US Highway 1. But he even admits there's a portion that there's no video for, to take SV1. It was after the crimes from 1122 captured on the 1112 camera, and then around to where it went to someplace, and it wasn't seen for several seconds, I think a minute or so, and he had to build that in. So some people feel that is one car that's going from Pullman, from his apartment to Moscow, and then back to Pullman in a roundabout way. Other people are not decided, but they feel that, hey, if I could take the text messages, forget about what anyone says that they are. I don't go by anyone. I don't care what the defense attorney said. I don't, as much as I don't care what the prosecutor said. We all are perfectly capable to look at evidence ourselves and come up with our own conclusions. And that is evidence, the text messages, the 911 call. How great would it be to be able to line up the text messages with what people think they hear on some of the 1112 camera, not sure what they hear on the 1112 camera. Those messages have a timestamp. In any event, I think the public should have received them way back when. This sealing of this file is very, very disturbing to me. There was too much that was sealed, beginning from when the MPD began their investigation. Look at what's going on in California with Reiner. This case is just a couple of days old, but yet LAPD has released images, photographs, and video of seeing him walking down the street, the defendant, arresting him, putting him into the patrol car. They've given already a few press conferences. Yesterday, they did a press conference where the district attorney came around and he said what the charges were. We had nothing like that with Kohberger. Everything was sealed. So, yes, indeed. Amy is saying, I'm here, got distracted. Groceries, forgot to say hi. Thank you. Thank you for being here. Leah, Jeff, hey, Jeff, good to see you here. And Lee, if Brian returned to the scene of the crime to see, I bet that he didn't go any further than the very top of Walenta. Well, we'd like to see that evidence for ourselves, Jeff. I know that you tend to believe, and that's your prerogative, what you're told by law enforcement. But I think a lot of people want to see the evidence for themselves because they don't want this country to turn into China or Iraq or Iran, and where there is no due process and where you have to believe law enforcement, and a lot of people want to see the evidence for themselves. That's it. There is no reason in the world for this case to be still under seal, Jeff, after 6 months. And if you could give me a reason why it is, I'd like to hear it. I appreciate your input and your opinion, but I say if people want this country to be like Iran and Iraq, go there for a week, see how long you last. When you're told what to do, what to think, and what to say, it's not going to be like this in this country. As far as I'm concerned, I'm going to fight to make sure that there is not another case that is prosecuted like this case was, under seal, like the public are a bunch of infants. We the public, we need to see these documents. We should have seen these documents when the case was prosecuted, because the public plays a role to make sure that people like Judge Hippler, Judge, Bill Thompson, Ashley Jennings, and yes, Ann Taylor do not abuse their positions. It's the public who's supposed to oversee and make sure the enormous powers the government has is not abused. I consider that. I appreciate your passion. Yeah, Cheryl. I mean, I love our country. I love the founding documents. I feel that the founding documents that started this country are brilliant. The underdogs of all underdogs fought to keep this country from becoming another monarchy. And they had no shoes, they had no food, they had weapons that were third class. They were up against the most elite military in the world. And they said, you know what, give me liberty or give me death. They meant it. They said, if I can't live, if I can't choose my own religion, if I can't be free to speech, if I'm going to have government treat me like I'm a baby, I'd rather not be around. I mean, that was the passion. And there were people that lived and died for that right that we have to due process, to freedom of speech, to freedom of religion, freedom of the press. And I'll be darned if I'm going to let someone take away those privileges from us. Like I say, if anyone wants to be told, go to Iran, go to Iraq, go to China, see how long you last. Probably, like that one basketball player that was on her hands and knees because she was sent to Blue Dolphin. She couldn't wait to come back to the U.S. that she badmouthed so much in our rights and privileges. Amy, need to wait to see the evidence. Yeah, how much longer, Amy? We have to wait to see the evidence. It's been 6 months since this case was closed. It was ridiculous, the amount of documents that were under seal. Oh, we were told, oh, no, public, you can't see suspect vehicle 1. I'm sorry. Mr. Kohberger has a right to a fair trial. The prosecution has a right to a fair trial. We have all these people that have rights of privacy. First Amendment, you go in the back seat. And then what happens? That Dateline special? Who had the audacity to take that video and give it to who they felt like giving it to? And stuff from supposedly the 8458 phone and everything else, when we, the public, were told we couldn't see that. And that's another thing. What's going on with this investigation of who not just leaked that information, but actually had the audacity to violate the non-dissemination order? If we couldn't see it as the public, someone who wanted to maybe to get in with Dateline, maybe they wanted to be a future person, panelist or something like that, or whoever they were. They had a lot of guts to do that when we were told for years we couldn't see that evidence. I want to know what's going on with that. It's something else that's under seal. We heard about that back in mid-May, that Judge Hippler was upset. He felt that the leak came from the prosecution or someone related to law enforcement. That is exactly what he said at the final pretrial conference. And someone like Judge Hippler, he had to have been told something or know something. And he said that was a violation potentially of due process, right to an impartial jury. He said that it would harm his right to an impartial jury, because we have to take a lot more time now to try to find jury power. And so someone has gotten away with that. No. That person belongs in jail. I don't care who they are. They have the audacity to do that. Hey, A.R. Hayes, how are you? Good to see you here. Amy, Leslie, and Billy. And yeah, definitely. Oh, so number 8 is saying, I'll never watch Dateline again. It's all BS. I didn't hear the words one time from any of those talking heads say that an individual in this country, unlike Russia and China and Iraq and Iran, has a presumption of innocence under our Constitution. And not one time did we hear that until or unless he pled guilty or he was adjudicated guilty at a trial that we all wanted to see and we were deprived of when he pled. He stood up in open court. He raised his right hand. I got to take that into consideration. I wasn't there. I don't know if he played a role in this. He says he did. He stood up there in open court and raised his right hand and pled guilty. What I don't think happened is I don't think this was a one-person job, not after reading the little bit that the public has been entitled to read from the autopsy reports through the state, what they were. Those injuries to Xana alone, how long did that have to take? And then he's got to attend to 3 other people. I have a hard time believing that this was a one-person job, that it was Mr. Kohberger alone, and not Mr. Kohberger with a co-conspirator, accessory before the fact, accessory after the fact, or maybe it wasn't him at all. Maybe it was someone else. So we need this case unsealed. And people have said, well, what can I do about it? What you can do about it is keep reporting on the case, talking about it, let your friends know, this is beyond, is he guilty or not guilty? This is an issue that our privileges, the founding documents of this country have been, I think, abused. We shouldn't be sitting here 6 months after he pled guilty and only have a couple of documents from January, February, from April, May, June, and July unsealed to the public. That is an insult to the public. He's acting as though he is a king. And that's why we got away from a king when the underdogs of all time fought for their independence. And then the original 13 states said, oh, no, we're not signing this Constitution. We need this Bill of Rights. And that's what got us the first 10 amendments. So on behalf of, I'm going to raise a glass of water here to the 13 original colonies, aka states, for giving us the first 10 amendments. And then we also cannot be remiss, we would be, if we didn't have the 14th Amendment, because then what that did is that made those 10 Bill of Rights, they were first only applicable to if the feds wanted to prosecute you, or if the feds would deny you freedom of religion, then it made it applicable to the states. The 14th Amendment, Section 1, Due Process Clause, and that says that you need, if the government's looking to take away, whether it's state or federal, your life, your liberty, or your property, they need to give you due process of law. That's 3 things. Notice of what it is that they're doing. Number 2, an opportunity to be heard. And number 3, critical, impartial trier of fact. Now, if this was, sometimes people want a non-jury trial. They want the judge to serve as the trier of fact. Okay, then you need an impartial judge. Other times, like in Kohberger, he demanded a jury trial. Then you need an impartial judge because of all of the important rulings that are made pre-trial and during trial and also at trial. So that's our precious 14th Amendment. Let's salute it and our great lawmakers who put that into effect at the time of the Civil War and shortly thereafter. So Bill Thompson had only tried around 4 unaliving cases, and they all took plea deals. Yeah, Leah, I have not researched him that much, but I recall that a lot of other people had reported that. Okay, BZ is saying, notice how Allen and, well, you know what? I would argue Mr. Kohberger did not confess. Mr. Kohberger did not stand up in open court and say, yes, this is what I did. Here's the unaliving weapon. He did not. He pled guilty. That's a big difference. And maybe if he had, we wouldn't have all of this confusion about this case. I don't know. Cheryl is saying she very much agrees about Dateline. So disappointed with them. I am too. Very insulting that this big trial that had been prosecuted pre-trial under seal for the most part was now they were literally on the steps of jury selection. This was mid-May. Jury selection was supposed to happen at the end of June. There were supposed to be these super secret jury questionnaires that were going out that we couldn't see. Some of them have been, a couple of them have, a couple of the questions, proposed questions for the jury questionnaires have been unsealed so far. But back in the day, at the time when all this was happening, oh, no. Everything was under seal. Jury instructions, trial briefs, what else? Anything attenuant to the motions in limine, all of the evidence of everything. And as I say, I'm very, very, very interested in looking at the documents from the end of December, because that's all of the important motions to suppress. Suppress what? Warrants on the grounds of Fourth Amendment violations. Now, I feel, I've said it before, I'll say it again. DeGan Taylor dropped the ball with those motions to suppress, because she did not argue standing. You need to argue standing. Why, for instance, Mr. Kohberger had a right to had a voice against this IgG testing. She didn't do that. She kept arguing policies and procedures. It was a losing argument. Case law said it was. I'm sorry, Judge Hippler was right in denying those motions to suppress. However, that does not mean anything with respect to what was filed under seal. The supporting documents I want to see, starting with that PCA. Because when you go back to the PCA, and I've gone back, we've dropped 16 episodes going through it page by page. You start to see how it was like things that were speculation were made in a way that they were facts, which they weren't. And you've got to really look at it word for word, line by line, page by page, to see what they did in going. And remember, when they went to Judge Marshall, they're not going with the evidence. They're not bringing in the sheath with them. They're not bringing in the video of suspect vehicle 1. That judge is relying on what Brett Payne signed in that 18-page affidavit of probable cause. That's it. I'm telling you, without that affidavit of probable cause, you might have never even known of Mr. Kohberger. So please go back. It's going to be 3 years that document dropped, December 29th, 2022. And please look at our playlist. We have, as I've said, got a playlist of the first 9 episodes. That's the first half of the PCA. And we're putting together the playlist for the second half of the PCA. I got 2 more episodes 17 and 18. Pages 17, 18 is where he asks for the warrant for Mr. Kohberger's arrest that was granted that same day, and that also led to the finding of an order of probable cause. Everything was based on that affidavit of probable cause. And so let's see some comments here. I couldn't believe it. I researched it according to Idaho law. Reasons for it to show open. Okay. Bad charge, true, changed. Seeing what where's the proof BK ever got out of his car? Yeah, usually in order to charge someone with burglary, you have to put them inside the house. The PCA doesn't put them inside the house. The PCA said, and I'm going to tell you something. I think the DM was used here. That's my opinion that I give under the First Amendment. Because if you look at her first 2 interviews, the one outside of the house, she said that she never saw the intruder's eyes. And if she didn't see the intruder's eyes, she didn't see the intruder's eyebrows. Sorry. You know who identified BK from his bushy eyebrows? Who do you think identified BK in the PCA by his bushy eyebrows? It wasn't DM. It wasn't BF. It wasn't any of the students that were outside of the home. Nope. It was Detective Brett Payne. By looking at Mr. Kohberger's photograph on his license plate, he made the decision that Mr. Kohberger was the same intruder, clad in black with the face mask and whatnot, that Dylan said that she saw. Now, what is he doing interjecting himself? And he's done that a few times in the PCA. He changed her testimony from her hearing Kaylee saying, "Oh, there's someone here," to Zana saying it's someone here. Unless you're in the house, You can't be given, evidence like that. So bear that in mind. I know a lot of people have some concerns about DM, but she never said he had bushy eyebrows. And I will tell you something else. When he was arrested and they showed her his picture, she could have very easily been, the queen of Moscow, the queen of, if she said, yeah, that's the guy I saw inside the house. She could not identify him. And she told them she wasn't going to lie on, and say that it was him when she couldn't identify him. She also said that he was about 5'10", about her size. They added on a couple of inches, made him 6 feet tall. They made him 6 feet tall. So this is why it is really important, in my estimation. If you want to understand this case, you got to go back. You got to go back to the beginning. You got to go to the foundation and look at what was said in that PCA in order to get that arrest warrant. And once they had the arrest, oh, and what about this? They got the pen, trap, and trace because they wanted to find out if he was stalking someone. Hello, what did Bill Thompson say 6 months later when cross-examining one of the defense's witnesses? You know that there's no evidence that he was stalking anyone, but they put that in the PCA to substantiate getting the pen, trap, and trace advice, and also to see if he was surveilling anyone. There's no evidence he was conducting surveillance prior to November 13th, 2022, or that he stalked anyone. But I guarantee the minute that people saw that language in that PCA, it's on page 16, that's stuck in their mind. And I bet that if you would ask some people today, do you think that Mr. Kohberger stalked the victims? They will tell you yes. And that's from the PCA that was implanted. And I think that was very irresponsible. You go on facts because this judge who's looking at this PCA is depending on facts, not what you think, not what you assume, but actual facts. And then the errors that were in the PCA, he puts in there, very important, where were Kaylee and Madison shortly before the crimes. He's got in the PCA that they were at the corner club at 1:30 a.m. and they were also at the grub truck at 1:30 a.m. Have you ever in your life? I mean, this PCA should have been pristine. It should have not had any errors in it, as far as I'm concerned. I think that the victims merited that. They merited a first-class investigation, and that PCA was a crucial part of this investigation. It had so many errors in it. How can you possibly say under oath that they were at the grub truck and impossible to be at the corner club and the grub truck at the same time? And this is what, when you look at this document 3 years later, you'll come to say, how was he even, you may wonder, you may say, well, you know what, this is just minor. Maybe you'll see it in that way, which is true. You can, but in my opinion, I don't know how she ever signed that document. I really don't. When you break it down and when you consider she is not seeing the evidence, she is dependent 100% on what he is writing under oath. They needed the deal made, no probable cause. So Amy is saying no probable cause. Do you feel that there was no probable cause at the time that the deal was entered, Amy? Or are we talking, in your opinion, at the beginning of the case, or even at the grand jury? Now, I know that we're sort of under a situation here where we don't know what happened at grand jury because it was under, under seal, it's secret. Something else that I really don't agree with. I think everything should be in the open. I think that they need to get rid of these grand juries and they need to go with a preliminary hearing or, some other, it can't be secret. Nothing about this country was ever intended for anything criminal to be secret. They're going back to some ancient tool that they used back in, in the British days, the colonies. Okay, it was language very accusatory. Oh, yes, Amy, thank you. Please hit the like. I'd really, 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 really appreciate it. In Amy's opinion, she says that there was never any probable cause. Amy, do you feel that the evidence is important to you to understand, maybe? I mean, maybe there's something there that we don't know. Maybe they had some other evidence that they were going to bring to trial that we don't know about that would have been the so-called smoking gun. We're not going to know either way until Hitler gets off strike or whatever he's doing and signs that order from 2+ months ago. Again, the first two orders he signed within 30 and 36 days. Some people are speculating that whatever this super secret thing that was filed by the state back on the 25th of November, public record, still not put on the public docket, that may have some reason. Some other people are saying it's because of what some of the FOIA requests have said. A lot of people are saying, hey, they thought that the public would lose interest after a month, 2 months, and the public's hanging in there. I know that a lot of the independent creators and journalists are continuing to report on the case. And I believe I have no evidence of this, but I believe that the Idaho State Police's recent explanation on that piece of paper that looked like an 8th grade assignment. It was supposed to be a press release, immediate release. It didn't have the ISP insignia on it. It didn't have who prepared it, didn't have a contact, didn't have for immediate release on it, which is words that you have in a media release or a public relations release. It was like a piece of paper. Some stuff was typed on it. It was the 6th document drop. I believe that they did that because the public had been talking about that one document from December 5th of 2022, that receipt. You know what that receipt was for? That was a receipt for the submission of evidence to be evaluated by the Idaho State Police. That's all that document was. And it had the names of suspects. Suspect number 1, we still don't know who suspect 1 is. Name redacted. And then it had Brian Kohberger, December 5th, 2022. I believe that the only reason why the ISP dropped that document a few weeks back is because they noted that the public were talking about that and saying, what do you mean, Detective Brett Payne, getting up on the stand as you did on January 23rd, 2025 at the hearings for the Franks hearing and for the motions to suppress? What do you mean that the first day that you heard Brian Kohberger's name was the 19th of December, when it says right here on a receipt from the Idaho State Police with your partner, Detective Blacker's name on it, submitting evidence for the ISP to conduct forensic testing on, with Brian Kohberger's name appearing? I'll tell you exactly where it appears. It's 5 pages. It's on page 2. I've done a few of my presentations in the past, and you can see what his name is and how serious of a document. That wasn't some receipt from a restaurant or something where people were having coffee and his name. No, it wasn't. It was on a very important document. I feel that you staying involved puts pressure on them to release the evidence. Otherwise, I don't see them releasing it. Not what I've seen here in the past few months. Okay, so what are you saying here? Amy's saying no probable cause ever. Probable cause no in the arrest. No match prior to the arrest. They used no probable cause needed. So Amy is very, very much. Leslie and Billy, I know that you are too. You want to see the evidence. We're going to continue to provide you with updates on the Kohberger case, but at this point, things are at a standstill. But my recommendation is stay involved. I know that some of the creators are doing things. They're actually invoking their First Amendment privileges of petitioning government for grievances. That's what they're doing. I've heard Dago and a few other people have written letters to government. That's what exactly, the First Amendment, freedom of speech, press, religion, to assemble peacefully. And then there's that 5th freedom, because we get 5 in 1. That's how brilliant the framers of the Constitution and the states were in demanding that. If you feel that government's not operating in the way that you believe it should be, you have the right to petition government. Some people sue the government to get public records requests that they were not provided with. Others will go to a city commission meeting and speak out. Others will request a meeting with their Congress people. Others will write letters to members of government, powerful figures in the government. All sign petitions and send it to their legislature. But I'm telling you, people lose interest in this case. There's very little incentive for them to unseal it. Okay, any comments, questions before we move on to a case that I am following that I wanted to talk to you a little bit about. And I believe that this will be the case of the year for 2026, which is right around the corner for many, many, many reasons. It is state of California against, and this is the case of the Rob Reiner, the Rob Reiner and his wife, very tragically unalived in their rooms. Again, as with the Idaho 4, at a place that they should have been safe, in their homes, in their rooms. They were allegedly unalived with the same type of, with an edged weapon. There was some information released by the medical examiner today that said that it was and multiple times that they were attacked. So I just started covering this case a couple of days ago. The Idaho 4 case is extraordinarily tragic. This case is extraordinarily tragic. To think that this could be, Cheryl's asking, I wonder if they have found the weapon. Cheryl, maybe. That's not, it could have been found on the property or at this hotel room that he supposedly rented. That they were been all over both properties the past, few days. So maybe they did. But in any event, the medical examiner reported that Mr. and Mrs. were both multiple times with, the same type of a weapon that was used on the Idaho 4, not suggesting that it was a K-bar, but it was that type of a weapon. It wasn't a firearm. You know what, H. Potter, I wanted to talk to you about it. I thought plea deal from the minute I learned about this case. You know why? Well, because California has what's called the McNaughton rule. And there have been, we don't know yet, and I don't like to put a lot of, accord on what, TMZ reports or what People Magazine reports or what mass media reports or whomever. But there's a possibility that he was not just a long-term abuser of substantives, but he had a very, very possibly serious mental health condition. And if that's the case, California has what's called the McNaughton rule. And this pure speculation I'm giving to you today, and I'd like to hear your thoughts, Cheryl, on this one, because I know you've been following this case very closely. Today was first appearance in court in California, right? The crimes occurred. He was arrested the 14th. He really should have been in court yesterday, the 16th, within 48 hours. And that goes back to our Constitution. That's what makes this country great. They can't take him and throw him in the Tower of London like the Brits used to do and just have him sit there for years until they rot. No, under our system of government, you got to be brought before the tribunal, usually a magistrate judge, for a first appearance. And usually what happens is that the charges are read to you, the defendant, in open court, and that is what happens at first appearance. And then they enter a plea. Yes, Judge. Okay, so Judge, he 2 counts. You can take a look on our community page. I posted count 1 from the criminal complaint. That is the information. Remember, due process, you're entitled to notice of what the government's charging you with. You're entitled to an opportunity to be heard. That's arraignment. And then the impartial judiciary, due process, 14th Amendment. They announced yesterday at a press conference, I don't know how many of you saw it, they announced what the charges were. 2 counts of unaliving, first degree, premeditated, and then there's some special circumstances. That was the weapon that was used, and then also because it's multiple, it's more than one unaliving. There's been some special circumstances, but you can read the first page of the complaint. Count 1 is not the father. Count 1 is the mother. So I'm wondering, right away I'm thinking, was the mother attacked first, Michele? Or was it the father who was attacked first, and maybe she passed first, and that's why he's second? There's always a reason why they're listed the way they are. Look at Kohberger. They've always been listed. Count 1 Madison. Count 2, Kaylee. Count 3, Xana. Count 4, Ethan, by the state of Idaho. And we have learned that what law enforcement believe in Kohberger is that the attacks on the third floor happened first. So that to me indicate we don't know if there was transfer that's all under seal. Let's not get started on that conversation again. But with regard to this new California case, count 1 is to the mom. Count 2 is to the dad. Now, how tragic of a case could this be? You have, forget that, they're famous, forget their parents. They're living in their home. They bring in their son to come live with them who's troubled, right? He's 32 years of age, should be on his own, but has had problems for years. And I'm wondering if it's more than just the substance abuse problems, and it might not be something like bipolar, schizophrenia, something like that. Today, arraignment, what's supposed to happen in arraignment, the judge is supposed to read in open court. This is all due process requirement, Constitution of the United States. You stand up in open court and the judge reads what the charges are and what the maximum penalty. So she should have gone today at arraignment, count 1. Okay, sir, you've been charged with first-degree unaliving of Michele. This is a violation of California code, and then they read the statute. And then there are these special circumstances of A and B having to do with the weapon, and then there is the fact that it's more than one, that he is charged. And again, we have to keep saying he is presumed innocent under the law until or unless he is either adjudicated guilty following a trial or he pleads guilty. He is considered innocent at this time under the eyes of the law. That is our Constitution. That's how it works. But today, arraignment is when the judge reads the charges that the people of the state of California have brought against Mr. Nick Reiner. And he's called, I thought his name was Nicholas, but his name on the information, aka criminal complaint, is Nick Reiner. It's the people of the state of California versus Nick Reiner. They give his date of birth. They got the case number, all of that information. I put the docket up there too, if you want to look up the documents. I very much always, if you're following a case, read the documents for yourself. You're perfectly capable of reading the documents for yourself and come to your own conclusion. So arraignment should have been brought before the court. Okay, Mr. This charge brings with it the maximum penalty of life imprisonment without the possibility of parole or even the DP. Now, people have said, yes, there's a moratorium since 2019. That is true. But they haven't taken the DP off the books yet. The legislature has not revoked the DP, as legislatures in other states have. So it's still a possibility on the table that he could ultimately face the DP. Now, someone had said that they thought he had heard rumors. I think it's H. Potter. I heard rumors that he is going to do a plea deal. I kind of, that's a theory of mine. Very, very early on in the case. Very, very early on in the case. We don't know the evidence. We don't know. I don't think he could have hired a better defense attorney right now in the United States. Alan Jackson, for those of you who watched Massachusetts versus Karen Reed, whether you like him, you don't like him, whether you like Karen Reed, you don't like her, he did a phenomenal job in that case in raising reasonable doubts and persuading that jury to come back. And this was the second go around, right? First time, hung jury, they couldn't agree. This time around, not guilty, not guilty. She walked. So Cheryl's saying, Kathy, I think he does have an existing mental condition, especially if this was premeditated. Well, Cheryl, here's why I'm thinking along the lines of a possibility. And again, this is pure speculation. We don't know. It's just the beginning of the case. All we have right now is the benefit of the information, the criminal complaint, the docket, what happened today. But I will offer to you, Cheryl, the fact that you got one of the best criminal defense attorneys in the country. So now the state of California understands that if this goes to trial, it's going to be getting down in the mud. They're going to be fought like they never probably haven't been fought before, although he is in California. But people know of him across the country and the world because of the Reed case. So if this does go to trial, there's going to be a battle, big time battle. And you never know what a jury can come back with. A jury, sometimes you see evidence, you're like, oh my gosh, this is beyond a reasonable doubt. No, every way, shape, and form, to quote Judge Hitler, if I might, every day of the week and twice on Sunday. This jury, they got to see this. This guy's guilty. This woman's guilty. They come back with either hung or not guilty. You just never know. It's always a risk what a jury is going to do. But today, we saw Mr. Jackson get up in court, right? Very, very quick proceeding. We were expecting it was going to be arraignment. The defendant was in the courtroom. I heard him say 3 words, confirming that, yes, he was waiving his right to a speedy arraignment because arraignment was supposed to be today under a statute of the state of California and the supreme law of the land, which is the Constitution of the United States. Today was supposed to be the day of his arraignment. Mr. Jackson basically got up and said, we're not prepared yet. So that means he does not know as of yet. He was just hired. Perfectly understandable. This case is brand new. It's a complicated case. There's a lot of moving parts. He's just hired. He is not going to jump in to do anything. He wants to get his ducks in a row, so to speak. So he approached the prosecutor and they agreed on January 7th. And then the judge turned to her side to where apparently he was sitting. I didn't see him at all. I was really looking. I went back and I played that 5 seconds of on-air time. I still don't see him, but you hear him saying, now, Mr. Reiner, you understand you have a right under the Constitution of the United States and the statute of the state of California to a timely preliminary hearing. That means today, but your attorney's just saying that you're going to waive it. You're going to agree to be in jail basically until the 7th of January. Not that there's any bail. He's held on zero bond. At first, I think I think it was Cheryl that you had correctly pointed out that there was bond of something like $400,000, and you opined that, hey, 10% of that 40, whatever it was, that would not be, I don't know if it was 4,000, it was 4 million or something like that. But you said, hey, a person of those resources might be able to pull it up. Hey, Kylie, so good to see you here. Thank you for making it. I'm so happy that you're here. Okay, so getting back to 4 million. Yeah, Cheryl, I didn't even know that. I didn't look that closely because that's all I had for a couple of days was the sheet from the jail, the sheriff's department. And you're absolutely correct. It was $4 million bail on that. And then they changed it to no bail. And now the actual court docket, which is available for you on our community page, no bail, no bond, no bail. He's staying in jail until the 7th. And that's when, and I think I heard Jackson say words to the effect of, it might even go beyond the 7th. I'm thinking to myself, okay, yes, H. Potter, Alan F. and Jackson. Alan F. and Jackson, H. Potter, and Cheryl, and those of you that are interested in this case, might be thinking a not guilty by reason of insanity. Now, we don't know. We have not seen his medical records. We don't know. But sometimes it's not just an alcohol or a rug problem. There are underlying factors people will do illicit to try to get to calm down the noise in their heads, for want of a better term. I've had a couple of people that are bipolar in my life, close to me, and when they took their meds and they were going to treatment, they were the best people you'd ever want to know. Then sometimes, oh boy, these meds for my bipolar, it's making me gain weight and I'm doing well and I really don't. And then when they go off their meds and they stop seeing their doctor, it is like night and day. So maybe he does, maybe he doesn't. That might be what Jackson's working on right now, because under it's called the McNaughton rule. Look it up in California. That's the standard, and it's not guilty by reason of insanity. And they have to establish. Now, it is the defense would have to establish, not beyond a reasonable doubt, but a preponderance of the evidence, which is a much lower standard, to show, okay, you have the trial, you establish beyond a reasonable doubt that this person committed the crimes, then the defense, then they get to put on their show. Yeah, he committed the crimes, but number one, he did not know the quality of what he was doing at the time. And number two, can't distinguish between right and wrong because of this medical condition. That may be, just throwing this out for discussion, I don't know how you guys feel, why he postponed entering a plea. Because it might be at some point, it might be not guilty right now, but it might be not guilty by reason of insanity, raising the McNaughton standard, which requires heavy duty. You just can't say, oh, I didn't know what I was doing. I would have never done this if I was in my, no. You need hardcore, good medical experts. So he may be being evaluated by a medical expert. I think Alan Jack probably knows a lot of very good and qualified medical experts. And then it depends on what that medical expert finds. If that medical expert finds and is able to testify, put their credentials on the line, get up in court, be subject to cross-examination by the state and say, hey, his brain is wired because of this medical condition, that number one, he didn't know the nature or quality of what he was doing at the time, and he could not distinguish between right and wrong at the time. Now, some people have said they're already ahead of the game as far as I'm concerned. They're saying, but wait a second here. He knew to get away. He wasn't there at the house. He knew to get away and go rent a hotel room, wash up, again, this is not evidence in a court of law. We don't know. So take this with a grain of salt. They're saying that he rented a room, Santa Monica Beach or somewhere, that they supposedly put up sheets to black out the windows, that they supposedly found the red DNA in the shower and his clothes. Whether or not they found a weapon, as Cheryl's saying, is unknown. Okay, Cheryl's asking a really important question. Kathy, if he were proved insane, would he walk free? No. Under California, do you remember John Hinckley? This might be before your time, Cheryl. He was back when President Reagan took office back in the early 80s. There were two attempts on his life. One was by a man called John Hinckley. John Hinckley, his defense counsel, got up and said, yes, he's guilty, but not guilty. He did it, but he's not guilty by reason of insanity. John Hinckley then went to a mental hospital, and he was there for decades. He was there from the 80s, 90s. He got released. I don't know if it was about 5 years ago, 8 years ago, because they found that he had been completely rehabilitated. And that's sort of like, I've done just some preliminary research, but that's sort of like how California works as well. Not easy to win. Even in California, a lot of people, oh, it's so liberal, it's this, it's that, it's the other thing. It's not easy to be able to win on this, but if someone's going to be able to prove it, of any other defense attorney in the country right now, I would think Jackson could. And so that might lead to a plea deal of some kind, that, hey, we're going to go for not guilty by reason of insanity, and then the prosecutor's got to think, wow, this is not an overworked public defender. This is one of the best criminal trial defense attorneys right now. That's how this could possibly play out. We don't know at this point. It could go to trial. Who thought Kohberger was going to plea? After we heard, oh, my client is factually not guilty, and they fought the way that they did for 2.5 years. Nobody thought that he was going to play. Very few did. Okay. Any thoughts? So we have Amy is doing her fireworks there. Mental facility, 10 years, don't know. Oh, okay. So Amy, you've done a little bit of research on California law. And so your research also shows that if he were adjudicated not guilty by reason of his insanity, or if there was some plea deal based on that, it's not a matter that he's going to walk out of the courtroom. No, it's a matter of he's not going to prison. He is going to a mental hospital. So we see here, okay, a self-medic. Yeah, Jackie. Sometimes I've done some research on people with hardcore mental illnesses, and sometimes they self-medicate to try to stop whatever it is that's going on in their heads because of the schizophrenia or because of the bipolar disorder or one of these other. Oh, and one thing I wanted to point out, you can't use the issue that, hey, I was under the influence of rugs, illicit rugs, H or whatever, F, that poison, or hey, I was blasted out of my head on alcohol. No, 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 no. That is not going to do it. That's going to get rejected. It's got to be a very serious mental condition that makes the person unable to differentiate from right and wrong, and also that they didn't know the nature or quality of what they were doing when they attacked. Amy is saying, honestly, I didn't think BK would take a plea, but Hitler a month and a half prior to plea and hearing everybody, so it was surprised, but wasn't as well. So you're saying that the motion to continue the trial was denied. The motion for the alternate perpetrators was denied. And there was a third motion, then the motions to eliminate, they were all denied. The motions to suppress were denied. The motions to set aside the DP were denied. Yeah. Right now, he is a danger to society. Oh, yes, absolutely, Cheryl. Absolutely. I think he was a danger to everyone he came across, including not just his parents, but everyone he came across. If he could, hey, again, innocent until proven guilty, but the prosecution is saying here that they believe and that they have probable cause to believe he was. Let's just say he did. Can you imagine, going to your own parents? And it sounds like they suffered a horrible, horrible, horrible unaliving. Honestly, I didn't think. We never know anything, Leslie and Billy. Yeah, you don't know until the evidence is released. The evidence is released. So if you'd like to look at the information, aka the criminal complaint that gives notice to Mr. Reiner of what he's being charged with, the first page is on our community page. We'll be doing some type of a presentation in the next few days to go over the entire information, aka complaint in this case, so that you can see the two counts. That's, again, count one is the mother, count two is the dad. I just don't see him if prior. That's too hard. Yes, yes, yes. It would have. Oh, can you imagine, Amy, if they recognize that they're there has been some, we don't know where they were in the house. There's been some insinuations that they were in the bedroom. There have been some insinuations that they were even in bed at the time. And to then not only recognize that if he did commit this crime, that he's not only attacking you, but he's attacking your partner of 35 years, your spouse of 35 years, and it's your son that's doing this. And he's out of control and there's nothing you can do to stop him. Yeah, I pray that they didn't as a parent. I'm with you, Amy. The Utah case, legendary. Hey, legendary. Good to see you here. Utah case is bigger. A lot of people agree that it is bigger. I'm very interested in that case for multiple reasons, especially because of the First Amendment issues, as I think I've discussed before. So we're probably going to be following that one too as it gets a little bit further on. But this Reiner case we're following from day one, like we did with Kohberger. We're going to go through all of the filings and all of the pleadings. Our first presentation, we've done a couple of episodes so far, But our first in-depth presentation is going to be of this criminal complaint and the information. Look for that in the next couple of days. Look for that in the next couple of days. Okay. So what Amy is saying, that was crazy too. Loving Utah is interesting as well. Oh, but what I don't like with the Utah case is it seems to be following the Kohberger case that they're sealing a lot of things. So right away, here goes my fear that Kohberger may have set a precedent for other cases. No, we can't have another case like that. What is your thought on how long it would be before they go to court or plea? Well, anything with a court proceeding, especially of this magnitude, Cheryl, nothing's going to happen overnight. If, and again, this is a big if this is what Alan Jackson is, because he's been to the house. He went there yesterday. Alan Jackson was seen getting out of a car, and of course the house is behind gates. There's some shrubbery you can't see once he went in the gate, but he's obviously there to look at the crime scene, to give him some further input onto the evidence possibly against his client. Maybe he went into where his client was staying. He was supposed to be staying on like a guest house that a lot of these, big houses will have out in California. So he's only been, I think this is only his second day of representation. I think that he only began representing him formally yesterday. So very, very early in the defense is going to have to now investigate as to if they're going to raise what they're going to do. I mean, we might go to this indictment on the 7th of January and he just pleads not guilty. And then they have to do the preliminary hearing. Remember, it's the same thing that happened in Kohberger, you guys. They go through those steps of, okay, they have the complaint. There's an affidavit of probable cause some cop signed that led to the state issuing the complaint, the information. That's got to be released. Hopefully that will be soon to the public. And then we'll get some information on what the evidence looks like. Then they have to agree to a preliminary. Let's just say he straight out pleads not guilty, or he stands silent as Kohberger did and didn't plea. And then what the judge does is as she enters a plea of not guilty for him. And then the next business is going to be, when is the preliminary hearing? And that would be when the state would be required to come in and to, in front of the judge, show what their evidence is to see if there is enough sufficient evidence to bind him over for trial. So that would be the next, I think. In the meantime, they're probably serving discovery on each other. Jackson has probably already filed a request for discovery. Discovery evidence, turn over all of your evidence in your possession, custody, or control that makes you think that my client committed these crimes. So he's got to go through all the evidence. It would be, I think, a few months at least. I think this will be well into 2020, unless there's something really unusual about this case. And then again, remember, the states will ask the family members how they feel. Right? The family members of the victims here are also the family members of the defendant. How do we like those? I mean, that's another monkey wrench here. When Thompson went to the 4 family members, they didn't know who Kohberger was, never met him. They had no ties to him. Here, the family, the surviving children, I think it's a daughter and a son, a brother and a sister from the same parents, and then a stepdaughter from the marriage to Penny Marshall. Remember, Rob Reiner was married to Penny Marshall first. And so there's another child there. I mean, they're all adults, they're not kids, but they're all related to the defendant. How's that going to play into it? If it comes out that maybe they know, hey, he was mentally, again, just throwing all this out. It makes it that much more complicated that this is family upon family, the alleged perpetrator and the victims, and then the survivors, the family members related to both sides. Good question, Cheryl. We're going to continue to monitor the case and see what happens. Yep. Hey, A+, Amy. All great input today. Wonder if they will bulldoze Reiner's Legendary CEO is throwing out a rhetorical question here. I wonder if they will bulldoze Reiner's house. LOL. Yep. That was a big red flag, wasn't it? Didn't even wait for trial before they bulldozed the house. There's no bigger piece of evidence, in my opinion, physical evidence than that house. Yeah, Cheryl, you're agreeing that this really throws a complication into the equation, doesn't it? Because the surviving three siblings may, and especially if he was undiagnosed, or maybe he was, and they know, that he had some type of a condition that made him that fit the McNaughton rule. We're going to have to just see how things play out. Can AT file Hitler for accepting this plea against Idaho Supreme Court? What do you now? I mean, at this point, he stood up in open court, Amy. He stood up in open court. He raised it. We all saw it, and he pled guilty. Now if he didn't know what he was doing, and if he was advised improperly, or if some new evidence turns up, that's a different story. But in my opinion, if any, and we don't have any evidence at all from Mr. Kohberger. He seems as though, as far as we know, he hasn't even, made any type of an indication that he would want to appeal anything. 18 trips to rehab, Jackie's saying, would be a lot of information. Yes, Jackie. Sometime, I watching some of these television shows, that they do have where they follow, Dr. Drew, and what was the other one, where they get together and they all get with the family members, come in, intervention. Sometimes when they go to these rehab facilities, and also based on my own research, there'll be doctors, there'll be staff there that may also diagnose and treat a mental condition as well. 18 trips to rehab would, Jackie, provide a lot of information. I really wonder what his parents would want. Yeah, Cheryl is throwing out the rhetorical question out there. I think from what I've learned, Michele and Rob Reiner were against the DP. They were against the DP. So that would be a really interesting thought. What would Michele, what would Rob want? Would they want him to go to prison for the rest of his life without the possibility of parole, or possibly even the DP? Again, we understand that there's a moratorium right now, but the DP is not, legislature has not revoked the DP. It is still on the books. What might the parents want? Good question. H. Potter is pointing out the oldest daughter is not blood related to anybody in the family. She was adopted. Right. She was adopted, but she considered Rob Reiner her father. Rob Reiner, from what I understood, considered her his child. But you're absolutely right. The blood relatives were the three children, including Nick, who was in the middle, I think. They're all 100% siblings. Jackie is really opening the door to the possibility that there is a mental health issue here. Amy is saying, on TMZ, adopted daughter left all 4 natural kids, got real estate access permission. Don't know if it's true. Okay, we're going to find out. We're going to find out in the days to come. Satire 777, so glad you're here. One of the members of our channel that I so greatly appreciate. Good evening to you as well. I'm glad that you're listening. Drive safely. Drive safely. Dawn, hi. Dawn's saying, I'm wondering why Hitler has gone quiet. Jules has been trying to get the footage that she paid for, and some important times are missing. No one is. Dawn, what? I had heard that Jules did pay out of her own pocket for some of the footage of SV1. I also believe Connor has put out some of the body cam footage. Very interesting. First time that we ever saw Lanier. We had seen photographs of Captain Lanier, walking from the front of the house to the back. But this body cam footage from Officer Smith now shows him walking into, which I still can't believe the number of times that they walked in and out of that backslider, if that was supposed to be the point of entry. And quite frankly, how many times they walked throughout that house with any booties. Every time, from what I've learned, every time someone enters a crime scene, they're taking DNA away, whether they know it or not, because they're stepping where they step. They may brush up against some DNA that's important to the investigation. They drop. We shed skin. We shed hair. We shed tears, whether we know it or not. We do all of these things. And so I'd like to know, what footage is Jules missing? And RC, thank you so much for your generosity. I appreciate the super chat very, very much. Yeah, I'd like to know, RC's asking, in your opinion, if BK wasn't involved in the atrocities, what happened at 11/13? What happened on November 13th, 2022? Could lawyers be paying attention to content creators and take on this case if there really is no evidence? I think a lot of people are watching the content creators. I do. And I'm not talking about mainstream media, because all mainstream media has been doing, RC, as far as I'm concerned, is report on stupid things. Our Constitution right here is at risk. We have a case that did not go to trial, that has been sealed from the public 6 months after the sole defendant who was ever charged with anything went to trial. And I believe wholeheartedly that the explanation that came out of ISP recently as to why Mr. Kohberger's name was on a receipt for evidence dated December 5th, 2025, is because they had been noting what content creators, what the public had been talking about it. Why the heck is Brian Kohberger's name on a receipt for December 5th, 2022? So I think a lot of people are watching the independent journalist, because I think that that's where the exploring of what's really important. Why is this case still under seal? That is my number one beef. Possibility someone could, step forward. But I mean, RC, he's got to want it. He has got to want to do something about his guilty plea. Now, I am also following State versus Wandra. This is a horrible case. The facts are as bad as they get. 5-year-old child, 2021. He's outside of his house. He's playing, and he was allegedly abducted to be bought and sold in commerce. Let's leave it there. And just this year, someone was arrested for the crime. The only person who's ever been arrested in 4 years. Probable cause affidavit is available for you to read. Mr. Wandra had pled guilty to another charge, a rug-related charge, and then he came back and he wanted to challenge it. And he got pretty far before they said, well, you didn't do this right. You should have done this. And now, if you want to come back and challenge it again, you got to do it a different way. But he got appellate counsel from the public defender's office appointed to him to try to challenge his guilty plea. Completely different fact pattern that had to do with rugs. This case, Idaho versus Kohberger, much different fact pattern. You're dealing with 4 un-alivings, different situation. So I think that a lot of people are paying attention as to what's going on in this case, and how the public is reacting, that people are taking money out of their own pockets to pay for very expensive information that I feel that the Moscow Police Department should have released a long time ago. Cheryl, thank you so much for your super chat. I really appreciate it. You've been a member of my channel for a very long time, and you listen to what I have to say. I take that to heart. Thank you very much. Thank you. I treasure and respect your opinions. I love reading your opinions. What you think about. I love reading what everyone thinks. I'm a big proponent of the First Amendment, and when the public stops discussing cases and starts saying that, yeah, we should have cases filed under seal, that's not a good thing. Hey, RC, thank you. Thank you for your membership. Thank you for joining us here, the Indie Zone. I appreciate it. Jackie is saying, I know what she's missing, and I can't remember what it's called. I would know it. Dawn saying, Amy, it's really bothering me. Jules and her community paid over $900. Wow. For that footage. Okay, wait a second. Dawn, I don't know if you had responded. No one's answering her calls. Would this possibly be the footage from the time that the girls were dropped off that would show the private driver coming down? Is that the footage that we're talking about? Hey, Jackie, welcome. Thank you for your membership and really appreciate it. Thank you for becoming a member of the channel. Are we talking about that footage? Because and I'm trying to think. I'm going off. I haven't seen all the footage that she put out there, but it seems to me it was like later in the morning. It was 4 o'clock. It was 5 o'clock, I think. And then I watched the one that was at the time of the 911 call, from 11 to 12. When you saw, that's when I saw, I'd been looking for this. I'd been looking for footage of first responder Snyder, how he arrived. If he arrived with the canine mobile, because that's his regular car. He is the canine team with canine officer Ragnar that I've done a series of investigations on. Where was canine Ragnar? The two of them were supposedly at a rug call. They were called out. There was an 11:15 a.m. call over on Main Street, approximately 2.2 miles at 11:22. It came in at 1 o'clock. It came in at 11:15 a.m. 11:30. They wanted the canine unit to go there. I don't know if it was to search a car. I don't know if it was to search a hat, whatever it was. But if you look at 3 calls from the call log for November 13th, the 11:15 call is for the rug call, a problem with rugs over on Main Street, nearby the Walgreens in Moscow, if that makes sense. Also, approximately 495 feet from where Ethan Chapin was seen the night before. Remember when he went to that Sadie Hawkins social or whatever with his sister? It was at a brewery, which was right by where this rug call came the next morning. Another odd coincidence about the case. So the 3 calls were the 11:15 call for the rug situation over on Main Street, the 11:30 call for the canine unit, and then 11:56, the call from 1122 King Road. Those were the 3. The canine unit were supposed to have been doing the canine search at 11:30. No report. Forget, people say, have you gone out and have you tried to get no report taken? What I'm thinking is maybe while Snyder and Ragnar are in process of doing the canine search, that maybe the call came out of this horrible situation on King Road, and maybe Snyder left before they were able to complete the search. Sometimes that happens if he's needed to. But what happened to the dog? Where's the canine? If Snyder is turning up for a canine search on Main Street, a mile and 1.2 miles away from 1122 King Road, it stands to reason, number one, he'd have his body cam on him, because I've never heard of a canine search, let's say, of a car, don't know if it was a car or what it was, without it being videotaped so that it can be used in court, which would be on the body cam of the officer who's conducting the search with his dog, and that would be one Officer Snyder. Now, on getting back to Jules's video, I had always wondered, why didn't Officer Snyder turn up, number one, with his dog, number two, with a body cam? Because if you'll remember, he didn't have a body cam right away. He had a body cam. It was given to him by Smith. So for the first 15, 20 minutes, no body cam footage of Snyder. But what the Jules video showed me is that he turned up with a regular MPD car. He didn't show up. And so I have been wondering, I don't know, we don't want to throw out theories, but what Ragnar sniffed for. These dogs, you see canines, some of them are for BO blank B, to sniff out the explode. Some of them work in schools to find firearms to prevent that tragedy, like we just had this weekend at Brown University. They'll have those dogs on campus to sniff and to attack if someone, a kid or an adult comes in wanting to cause some chaos in a school. Those dogs will run for them and attack them. Then you have the ones that was Ragnar. Ragnar was a rug sniffer. He was purchased in 2021, late 2021, the Moscow Police Department. And I have the minutes if you're interested in one of my presentations. MPD went to the city commission, they said that they wanted to purchase a canine, very expensive. This isn't just a pet. They've got to go to canine school. Their schools sometimes are longer than adults that go to the police academy. They needed money for the canine to either buy a new car that would transport the dog, the canine, or upgrade an existing MPD car, and then for the money that it would take for both of them. The handler, that would be Snyder, would have to go to Ragnar to school. And what Ragnar was trained to do was to sniff out rugs. It was sold to the city commission by the police department to help the police department deal with Moscow's growing RUG problem. Now, we've seen on body cam, that one woman that was arrested with her boyfriend. They called the Bonnie and Clyde for that tragedy that happened in Washington State, where that student was, passed. This was about 4 or 5 months after 11/22 King. It was the F drug on top of the C drug. That F drug is poison. Poison. That's what Ragnar was trained to sniff out. That was his specialty. So my question is, if you have this horrible situation, quadruple unaliving at this home, and there's a situation where this may or may not be a party house. There's nothing that evidence within the case. Of course, it's under seal, but it might or might not be. Who use a little bit of common sense. Who distributes to kids on campus? They're not going to go downtown into a shady area and try to, purchase something. They're going to purchase it from someone associated with that. Is the case in every university or college. And as much as we want to sit here and say it doesn't happen to the college where my kid goes to or went to, we're fooling ourselves. These kids are susceptible. They're 17, they're 18, they're away from home for the first time a lot of times, and that's where they experiment a lot of times. And to have that F and YL in it, it literally, it stops the respiratory system. That's why it's so dangerous. Yeah, I miss Tommy too, Jackie. He was a big proponent of mine. He showed a lot. He showed my videos. He liked my videos. One of the last ones that he showed was on the Idaho 4 defamation case, Schofield versus Guillard. They were not sure why that case is in federal court, not state court. That case is getting ready to go to trial, by the way. So right now we're following 4 cases. We're following Schofield versus Guillard. That's the case where the University of Idaho professor sued a TikToker / psychic who she says publicly went out and defamed her, saying that she had something to do with the crimes and had also was having an affair with one of the students. That case is getting ready to go to trial here in February. We're covering that case. We're covering Idaho versus Wandra, of course, Idaho versus Kohberger until they unseal this case. We're going to continue to cover it. I thought I was going to be done with this. I really did. I thought, hey, we're going to trial in August. Hippler says he's going to move things along. It's going to be 12 weeks plus penalty phase, if any. That'll take us to. I thought, okay, maybe the end of the. I was looking for other cases to cover besides Kohberger, but got to stay on Kohberger until the case is unsealed. And then also now we're doing the new California case. So we have 4. But Tommy, yeah, he played my videos, including the Idaho 4 case from time to time. Hey, Blueberry the Great, another member of our channel. Good to see you here, sir. And nothing is known. Yeah, Blueberry, until we get this case. And I don't know where Judge Stephen J. Hippler is. You know, I hate to sound like a broken record, but we got to go over it again. Here's the facts. He put out 3 orders so far to unseal documents. First order dealing with the documents that were sealed June and July of 2025. He rendered a ruling and started to unseal stuff in 30 days. Second order dealing with the documents from April and May of 2025. He rendered an order within 36 days. This third order for January, February, and March, where we get into, and I'm going to have to quote harsh here, the meat and potatoes of a lot of stuff, because that's all the evidence in support of the motions in limine. It's been 62 days without a ruling. Tomorrow will be day 63. And then we're going to get into the holidays very quickly. So are we going to go into January before he makes a ruling? For last January, February, March, and where again is the 4th court order taking us into the end of the year of 2024. A lot of information in there I got my eye on as well. It's all the motions to suppress, all the warrants. Hey, Love Gigs, so glad that you're here. Thank you for joining us. Thank you. Join in. Make your voices heard. Speak with your fellow members of the public. If you have any comments, questions, opinions, please leave them here. Yes, Jackie Bushable, I recall exactly what you're saying. Even JD said that there were always people in and out of that house. He said, in his opinion, he felt that too many people had the combination to that front door, and that front door had not been serviced in 2 years. The documents that the ISP dropped the first time that they dropped their documents, they interviewed the property manager, and she confirmed that the last time that property, that front door had been serviced and the combination changed was like 2 years before. So it's all of the people that lived in the property for the 2 prior years, plus all of these friends. I can't say that I blame JD, and I want to use this opportunity because I've just been over the affidavit of probable cause, line by line, page by page, to address the multiple errors that were in there and the multiple facts that were packaged as though, not facts, opinions, speculation that were packaged as facts. I still do not know why Detective Brett Payne named JD, first name and last name, on page 2 of the PCA. Just imagine. This was a high-profile case. This case had global attention on it, not just attention in Idaho, not just in the United States, but globally. People had very little information about the case by the time of Mr. Kohberger arrested because of the lack of transparency by the MPD. I am sorry, but they released nothing. Not even. Look at the Bolo. The Bolo. They supposedly had all of this video of suspect vehicle 1. They couldn't put in a screenshot of the actual SV1 with 2 stock images. No. They put in 2 stock images, one with a sunroof. They wouldn't even publish a still of the actual SV1. They had a witness who testifies that she saw this intruder. You're not going to do an artist rendition. You're not going to throw down photographs of the person that you think is that intruder and have DM herself come in. DM, do you see photograph 1, 2, 3, 4, 5, 6? Does this look like the person that you saw in the home? They never did that. It was Detective Brett Payne who identified Mr. Kohberger, who found that Mr. Kohberger was the height and the weight and the bushy eyebrows of the intruder. That DM never said that she never said bushy eyebrows. She had 2 interviews on that first day. One by first responder Nunez right outside of the house, and then one down at the MPD but with Mallory. She never said anything about bushy eyebrows there, and that's so important because that is the closest to the timeline of the crime. That is the best description you're going to get, in my opinion, because you're just up. They all okay. Forget. We're going to put aside the 8-hour gap right now, but at 12 o'clock or 12:10 or whatever it was, when Nunez starts asking her questions, there is never going to be a closer time to interview that witness than that moment in time. She never said she saw bushy eyebrows. Unless she called Moscow and Jackie Lana called Moscow to ask how Judge Hippler was doing. Okay. I hope he's okay. Thanks, Jackie. I appreciate it. Anyway, I want to get back to JD because I feel that Detective Brett Payne intentionally threw him under the bus, and I don't understand why. Detective Brett Payne, when you go back and you look at the PCA, you're going to see on page number 2, the medical examiner who performed the autopsies. This is a public servant. This is a state medical examiner. Her name was redacted completely to protect her identity. Some people said because they didn't want to let out what the name was, so the press would be all over her to ask about the autopsies. I'm not going to go that far. All I'm going to say is, hey, you're going to publish JD's name, you should have published the medical examiner's first and last name. If you're going to publish JD's name, not once but twice, when people are all over the place, they're trying to figure things out. You got the armchair sleuths, and now they got his full and his first and last name published twice by Detective Payne when that PCA was produced to the public, as it was the day that Mr. Kohberger voluntarily returned from Pennsylvania, which I think was another bad idea on the defense part. I'll tell you why in just a minute, and went to Idaho. That's when the PCA was given to everybody. The public got it. Now you're wondering who could have done this. Horrible people, parents. Oh my gosh. I had kids in college. I can't relate. I go to college. I'm afraid. Am I safe on campus? People were going out of their minds trying to figure out what happened here because Moscow Police Department refused to do as other agencies do. They'll release the 911 call. They'll release a transcript of it. They'll show the sheet, something like that. They did nothing. So now you have that environment where JD's first and last name's published. Okay, well then you should also publish, as far as I'm concerned, more so, the private driver. Why are you protecting his name? His name was redacted. They didn't even give initials. The 2 surviving roommates, they gave their initials. The DoorDash driver, the most ambiguous of all. When I said, what? She's at the property at 4 o'clock. That's the start of the timeline of the crime. Or we didn't know what the gender was of the DoorDash driver. He refused to say if it was male or female. Refused to say where this DoorDash delivery. And I got to say this because some of you feel that it wasn't a delivery, was allegedly or was brought to the home. Still in all, it's 4 o'clock. It's the start of the timeline. He doesn't publish her initials. He doesn't give her name first and last. She's arguably the last person at that property to see the victims alive that's not inside the house, not one of the 6. So you're going to protect her identity fully, not even giving what the gender was. You can make your own conclusions as to why they were so protective of her. She didn't come forward. That's another thing with the PCA. Leaves out, the DoorDash driver confirmed that how'd you get the DoorDash driver? She lives in the community. She's driving around Moscow all day and night. She come forward the next day when she heard, I was at this place at 4 o'clock and 4 people were unalived inside. No, she did not. They had to get a pen, trap, and trace device to find her. And then, what was it, a week afterwards, then you see Detective Payne with the interview of her. They make like she came forward voluntarily. Getting back to my immediate point. Something with the PCA, I don't like that they published his first and last name. And I'm going to leave it at that, just in terms of why are you treating him differently? Why aren't you protecting his identity? He didn't see the two of the 4 victims at, 2 o'clock or just minutes before, like the private driver did. He certainly wasn't on the premises at 4 o'clock in the morning, like you're saying the DoorDash driver is. Why this double standard, Detective Brett Payne? Cheryl, thank you so much. I'm so glad that you joined us here this evening. Stay tuned. We're going to be we're doing a lot. We got a lot of work to do in the California case, and I'm looking forward to your comments. Thank you for being here this evening. Kathy, but why? There has to be a why. Leslie and Billy, that is a $1 million question. And if I could answer that, I'd be $1 million richer than what I am right now. Okay, so Kathy, do you know who Vincent is? Nope, never heard. Lyft driver name was mentioned in Reddit. No, never heard. I'm sorry. Sorry, I don't. And then we go, interesting. Dawn saying, Lana knows how to investigate, no doubt. She does her research, brings receipts right, and shout out for keeping this eye out for the new documents and explaining them. Thank you. No, that's my job. I feel that, I was trained in the law, practiced, retired, taught, whatever. And I certainly don't know if my car breaks down. I don't know how to fix it. I have to depend on someone else who was trained to fix my car, a mechanic. I can't cook very well. If I'm starving, I have to depend on someone to make, a nice dinner for me. If I have a toothache, I have to go to someone who's trained for, the dental field. We all have, all of us, the truck driver, people that bring the food to my grocery store, I depend on them so that when I go to the market tomorrow, there's milk there and bread that I need. We all bring something to the table. And my goal is to, whatever I can, explain stuff like, what the heck's emotion? Emotion is, when you hear motion for lemonade, emotion in that motion, just think about it, that the parties can't go to the judge. They can't call the judge up and ask for an order. They got to do it formally. They got to make sure that there's no ex parte contact, so there's favoritism. They have to file what's called a motion. A motion is a request for a court order. They're bringing something. Hey, Judge Stephen J. Hippler, we need you to, in limine, make this ruling to keep out this IG. Did you ever hear anything in your life? Keep out the IGG evidence. How long did they fight over that IGG evidence, the two sides? There was hardly anything that was more hotly contested than that. Am I right or wrong? Going back to Latah County days, how many discovery requests, motions to compel discovery, hearings before judge, orders from judge. Yes, you can have this part of the IGG, but you have to sign this. Yeah, nobody else can see it. It's got to be dealt with the utmost of care, because these are informants, maybe not informants in the traditional sense, but their identities need, they've hundreds of hours of time. And then motion in limine. Judge, we're not going to be using, don't worry your head about it, state. We're not going to be using IGG. What? And then the infamous homework assignment, where Judge Hippler said, okay, the two of you're going to come up with a proposed jury instruction that Brett Payne is going to read when he gets up on the stand to say this, okay, well, this is how Mr. Kohberger's name came on the MPD radar. And hey, don't look behind the green door. Don't bother yourself. No concern. Don't ask questions. Don't think. I've had people who have served on juries and said, number one, if the lead detective of the case gets on the stand and tells me, or the judge instructs me, or however it was going to be, don't look behind that green door. They told me they would be wondering night and day what was behind that green door. So it's like all of a sudden there was supposed to be this homework assignment. They came up with the proposed jury instruction. It was one of the things that was released with the last batch, if you'd like to read it. In your life, have you ever heard something like that, where they're going to intentionally deceive the jury? I don't know what word to attach to it. Okay, so Amy is saying they work with W. Yeah, Amy, I thought that it was rather peculiar as I reread the affidavit of probable cause. Again, I've probably read that document backwards, forwards, up and down, maybe 10 times. When I say read it word for word, because you miss stuff and there's important stuff in there that you miss. Read it word for word. And it just seemed rather peculiar to me that you have these two college towns, as Detective Payne said, and there's a lot of back and forth between the students of WSU and Idaho. They go to the University of Idaho. It seems to me that law enforcement within 10 miles, both of them, on campus, college towns, would also be integrating and know each other. So you have two, not one, but two WSU officers within 30 minutes of each other after receiving that bolo with the stand-ins, as we call it. The one car with the sunroof and the other one without a sunroof, because for some reason, Moscow Police Department couldn't release a still of the real suspect vehicle one. So here we go. I think it was, what was it? What was the date? November 29-ish, around that time. You had one officer, Officer Whitman, and then an officer, I think Garcia. Garcia first, Whitman second. Oh, Garcia's walking around. He's doing his duties. It's midnight on the 29th, and he comes across Kohberger's car, and he got the bolo. So he turns in Kohberger's car to the Moscow Police Department located across the border, a mere 10 miles away. Half hour later, in this tiny, I mean, this isn't New York. This isn't LAPD where there's hundreds, even thousands of officers. What do they have? Maybe 20 officers who patrol that campus for WSU. So just out of the blue, these two officers happened to be working that night, and both of them turned in his car. But MPD says that, oh, no, Mr. I think that's when he came on their radar. For those two reasons. Number one, it was not one, but it was two law enforcement officers from WSU who called in after Moscow Police Department put out that bolo asking for. So these are basically colleagues right down the road within a half hour of each other. I think that's when he became a suspect, although Detective Payne says that it really wasn't until the 19th of December, after the infamous team meeting, that he ever heard of Detective Payne, of Mr. Kohberger's name. And then you got to throw into the mix, of course, this documentation that the Idaho State Police had to come out and make this correction over the receipt for evidence submitted to the Idaho State Lab by Moscow Police Department, and more specifically, Detective Payne's partner, who he arrived at 11:22. That would be Sergeant Blacker, with BK's name on page number 2 of that receipt, December 5th. Okay, state said they had video BK leaving the apartment. Where's his return? Never a word. I want to know. Here's what finally a light bulb went off in my head. It took the 11th reading of that PCA to come up with this one. You remember the part where they're saying, hey, we got suspect vehicle 1 caught, left and right here on the 1112 camera. Now, no, does the 1112 camera point toward Queen Road? No, it does not. Does the 1112 camera point toward 1122 King Road? We don't know. There's some talk that there might be a back camera on 1112 King Road. I can't confirm. I can't deny that. I'm just saying what's been thrown out there to make sense of what's in the PCA. The PCA says that, okay, suspect vehicle 1, comes into the neighborhood, drives down Queen Road, turns around, makes the infamous 3-point turn in the middle of King and Queen, drives back down Queen again, and then attempts to park and turn around in front of 1122 King Road. Once again, let's say this again, because it took me, like I said, 11 times to realize this is what Payne was saying in the PCA. I think it was right after the 3-point turn. He writes words that suspect vehicle 1 attempted to park in front of 1122 King Road, but was unsuccessful in their attempting to park in front of 1122 King Road. This is the house. And then they also attempted to make a turn in the middle of Queen Road. You know how narrow that is. That might have been difficult, unsuccessful. What camera picked up? What camera that we know of picked up suspect vehicle 1 attempting to park, but unsuccessfully, in front of the 1122 King Road house and also attempted to make a turn in the middle of the street in front of the 1122 house. Can't be the 1112 camera. The 1112 camera points in the other direction. What do you guys think? Amy, so you talk, hey, if there's video of him leaving in his apartment, that's one thing. I want to see the video of suspect vehicle 1 making that turn in front of 1122, or trying to and attempting to park, because you know what? If they've got video of suspect vehicle 1 attempting to park in front of 1122 King Road and trying to make a turn unsuccessfully, you know what else they probably have video of? Let's try. Oh, well, what about this? What about the private driver supposedly dropping off Kaylee and Madison in front of 1122 King Road? What about possibly Madison and Bethany walking Murphy sometime after 2 a.m.? You know, there'd be a lot of things. They got video of the front of that house. You might see the perpetrator entered. I don't believe, I'm not going to sit here and say I believe that the perp entered and exited through the back slider. There's a possibility the perp could have entered through the second floor slider. Perp could have entered through a window. The perp could have entered through a front door. You know, that's the camera I want to hear from. Amy has just, not only has Amy shot off the fireworks, but she's also made a cup of coffee too. Thank you, Amy. Lock the door. Okay. Yes, Amy, I do recall. Remember early on, Olivia was on top of things right away. And we're talking Olivia Cadley's sister. I 100% remember early interviews where she said she was the one who located the grub truck video. So that's how they found out the time frame of when they were at the grub truck. And that's how they found out that the other person with, because apparently the private driver didn't know who Madison was. Said Kaylee and, you know, another young lady is who he brought home from the grub truck. He didn't even know who she was. Then, but then we have Olivia saying that, yes, she'd gotten hold of the private driver. I believe she got hold of the 1112 camera footage also. And she had said that she had seen the dog being walked. The dog being walked. So I'd like to know where that is. I don't know, Jeff. Isn't that a business that shared it with the Gonzalez? I don't know. No, I'm talking about the 1112 camera. Yeah, the camera. I don't know. You know, what did you say to Adam? I told him everything. I don't even know if I hear that. You know, a lot of people have gone off on tangent. You know, kind of said, okay, well, there's something with Adam, the bartender, and I don't see a lot of things and hear a lot of things that others do. You guys, I know that you're specializing with the audio, Jeff, and maybe that's what you hear. I don't know if it did. Okay, so cops, a lot of, yeah, I mean, Amy, you know, without throwing shade on anybody, without accusing anybody of anything, imagine the LAPD walking up to a home where 4 students were unalived, just say it's outside of UCLA, and they're met by somebody with a sharp weapon in their hands. I don't think that weapon, it seemed like there were 2 of them. You know, now I have to say my vision is going, you know, in my old age, but I thought I saw 2. And I also thought that I saw one of the witnesses, M, saying that there was one at the top of the stairs and then one on the table. I can guarantee you that neither one was tested by the Idaho State Police, and the Idaho State Police, don't blame them for whatever was tested or not tested. They didn't decide. It was Moscow's police department as the submitting agency who decides what is going to be submitted for forensic testing. Okay. Private driver is shady to say. Jackie is saying he was off. Well, hey, we're absolutely, we're waiting. This goes back to how important these text messages, you know, that were submitted with the motions in limine that we 100% Judge Hippler saw, because he took the text messages and he did this really detailed chart of what he says the text messages say. You know that there was, oh, this is something the private driver somehow didn't say, didn't remember when he spoke with Sergeant Blacker the day after the crimes. He somehow forgot to mention that a young lady within the house texted him wanting to know if he was still driving. What was it, at 2:10 and 2:12 a.m.? And Judge Stephen J. Hippler documented those times. Who it was DM to the private driver, and the private driver writing, communicating back. I'd like to see those texts for myself. Remember, a witness left a tip that when he saw, that was, and isn't it interesting to see the witness walking back and forth now that we have some of the videos, RC? We've heard about this for so long. That guy even went out and he gave an interview right away. Remember, I think it was like maybe a day after, 2 days after, he's giving interviews, and then he stopped. He stopped after that because everybody was, I guess, investigating him, wondering if he had something to do. But yes, he said he walked past the house. The front door was wide open, and you see him with his little dog now in some of the videos. Said to me that the smell of the grub truck food came and had made others want to go. Could be, Jeff, but then again, who's it's hard to know who was doing what. According to Judge Stephen J. Hippler, the girls were upstairs in Kaylee's room with the exception of Zana. Zana and Ethan weren't home at 2:00. They were up there at about 2. He doesn't say for how long. And yeah, I could see where, oh, geez, I'm hungry too. And wanting to know maybe if they could go out. But then it comes out that, no, well, wait a minute. Bethany and Maddie are walking the dog at that time. But then again, there's all of these calls supposed to be going to JD. Very, very confusing on my mind. Frats in training to 911 call on. Okay, use the code Frax Rovax. Who's Pinterest? I don't even know what Pinterest. I think it's a social media account is crazy. I hear the officer on body cam say to Hunter, "You better give me the knife." And then you see her the sound of it placed on the beer pong table. Wasn't on, and then it was. Oh, okay, Jeff. Okay, I'm going to take a look at that again. Thanks. All right. Yeah, I think so, Amy. I do. But I'm really recommending that you go back and you read the PCA again, do it yourself. Sit down when you have time to do it. You might need to break it up because there's a lot of information in there. And see how you feel. See if it held up over these 3 years. There might even be, a few points in there. Like I'm saying, it took me the 11th time to go over this document before it finally dawned on me that they're saying here that suspect vehicle 1 was caught on camera trying to park in front of 1122 and try to make a 3-point turn in 1122. What camera caught that? And if there's a camera that caught that, there's a camera that should have caught a heck of a lot more, such as, again, not just the private driver, but also the undercover car, because the undercover car said that they circled that street. Tisdale, who wrote a report, said he saw people standing around 1122 at one point. He saw cars parked near it, but he's driving, so he can't look over and see what's going on and drive. But what about your partner? What was Rosendahl doing? If he's supposed to be your partner, wouldn't he be looking out the window to see what's going on? Of course, we don't have a report from Rosendahl. If Rosendahl wrote a report for his activities of the evening of the 12th into the 13th, it's never been released to the public. Tisdale's has been released. That's a really good report. Read it if you haven't had an opportunity. Didn't even notice the business videos were unreal. Okay. Hunter explained to the cop. Suspect making a brief attempt to barrel. Just looked at it last night. Okay, yeah, do that, Jeff, because I'm very curious how that camera, being that it faced forward, could have caught something driving. I'm really interested in that. Let me know where it is, please. All right, guys, we're going a lot longer than I typically go. Oh my gosh, we're going 2 hours. Never do go this long. It is getting to the time where I have my milk and cookies, more milk and cookies, and tuck in for the night. So I do want to thank you all for a great live. I really appreciate. I love your input. I love that you talk to each other. I love that you're discussing. I love that you're interested in the case. I hope that you will follow this new case and join in the conversations. I know a lot of people are still debating Kohberger, but look, we really don't have a lot to go on until Hitler decides to, start releasing some stuff. So maybe in the meantime, we can start discussing this other case. I'm predicting it's going to be one of the big cases of 2026. We're going to be putting out a video shortly going over this criminal complaint. Hopefully, they'll release the affidavit of probable cause and take a look at it. Oh, it's my pleasure. Thank you all for being here tonight, and please make sure like our share the videos if you like the content. Let's get the word out there. My goal is just to make sure whatever your thought process is, just make up your own mind, and you're perfectly capable of reading the documents and doing it, and comment on each other, debate it, and let's hope that we get this case unsealed sooner rather than later so that we can understand what the evidence is. And once this case is unsealed, we may understand, okay, this makes perfect sense. This is why he pled. This is where the reasonable doubt went away. Or, okay, this looks like it's not him, or it's looking like it's him and someone else, or it's looking like it's him and an alternate perpetrator, or the alternate perpetrator only, or an accessory before, or an accessory after the fact. We're only going to know that when the evidence gets unsealed in this case. So focus on the evidence. Thank you so much for being here. I appreciate all of your time. Have a good evening, everybody. Until next time, this is Kathy signing out. Bye.